let's move forward on industry protocol on submissions. So, all of these things that you've been talking about are the real reasons why people need to work with an attorney. They really need to have that protection, but like you said, your best clients are the ones who've already been burned. But a lot of times the reason why people do pull on somebody, bring on an attorney, is because of the protocol on submission. So can you talk about what that protocol is in the entertainment industry specifically, and especially with you being there in LA proper?
Well, yeah, the protocol is usually someone will be interested in your project. I mean, this is kind of the typical way is someone a little bit lower level at the studio or the network sees a project that they see potential in, and they want to get a little bit more information. Typically, they're going to say, I'd love to get your submission, but I need it to be submitted by an agent or an attorney. And why they say that is because it's for legal purposes. If everyone was able to submit, and there was a similar show that came out, then that person would feel like the network stole the show. So the network likes to go through attorneys and agents because there's a paper trail of who's submitting what. And they always make you and usually when you say, okay, I have an attorney, I have an agent, usually the next step is they're going to want you to sign a submission release, which says, sure, I'll review your project, but if by chance I turn it down and I use a similar project, you're not going to sue me. That's what the network and studios usually send. And can you negotiate those? No, not really, because they kind of hold all the cards. So you can't negotiate, your protection that way. But your protection is kind of using the attorney who's corresponding with these people and documenting, who's seeing what. And if something does happen, then you've got a person on record saying that something was taken from me, like my idea.
Go ahead.
Oh yeah, I was just going to say after that, then you submit the project, and hopefully they'll contact you and they'll be interested, and then there can be a deal.
I am so glad that you framed that the way that you did, especially about the release forms. Because as a producer, I do get a lot of people who want to send me information, and if anybody sends me a treatment or a screenplay without a release, if they have my email and they send it, I will not read it. I won't even look at it, just because of what you mentioned with the paper trail. Who wants to be sued? I mean, your whole company could go under just for the fact that, it's all the time and resources required just to defend yourself against the lawsuit. So that's why it's not negotiable. And here's another thing, and maybe you can speak to this as well. Generally, there's a way to get around the catch-22, and you mentioned kind of having a contact at a studio or a network on a lower level, or having an independent producer is a great way, like if you're a screenwriter or a director, to get in the door. A lot of times, if you get an email, if you go to a conference and you get an email and you say, hey, I have this project, and you say very, very little about it, which, is the beauty of a log line, and knowing how to really master that, then they can say, hey, yeah, here's a release, go ahead and submit it, and then you kind of have your, foot in the door that way. But I have seen people who want to submit projects, and they want an NDA. And, can you speak to why you will not get a production company, a network, or a studio to sign an NDA on a submission?
Yeah, I mean, they're just not going to do it. They don't really give a reason, but I mean, the reason is because of litigation. I mean, LA is very litigious, and with hundreds of thousands of people submitting ideas, you're bound to have similar ideas submitted and projects. So, there's no way that you're going to get a studio or a network to sign an NDA. It's just not going to happen. So if you and a lot of people won't accept that, and they just keep trying. But if you want to be in the industry, you're going to have to accept that, because that's just it's not going to happen.
Right. And I'm glad you said that, because
I advise my smaller clients the same thing. Really, I mean, once you sign an NDA, and NDAs aren't usually worded narrowly. They're very, very, very broad. So, I mean, you're just asking for a lawsuit.
Yeah, that's a really great point, and I can certainly think of projects that are in limbo because of, it's not that I don't understand people's concern, but they have to understand, like you said, there's so many submissions, so the competition is already heavy. Studios, networks, production companies don't want the liability. They don't have to take on that liability. And here's another thing that I'll throw out there. Keeping track of multiple NDAs makes no sense. Like you can't remember all the provisions when you get thousands and thousands of submissions. So it's much easier to have a release form. So I'm really glad that you touched on that as well. Okay, so now we've talked about the industry protocol on submissions. Let's move on to what to expect when working with